Hi, this is Eldad Moraru, Your Personal Realtor, and I'm here today with Matt Alegi, Settlement Attorney from Shulman Rogers. Matt, thanks for being with us.
No problem.
The question and what we are going to talk about today is what are the different ways one can take title? What are they, and what's the advantages of one over the other?
Sure. In the local jurisdictions, there are three different ways that multiple people buying properties, two people buying one piece of real estate, can take title, can take ownership, can hold ownership of that real estate. I'll say it's very important in most circumstances to do that in conjunction with your accountant, your attorney, or your other advisors, because there are some pitfalls regarding the different ways to hold ownership. But very generally speaking, two people buying one piece of real estate, if unmarried, can take title either as tenants in common or as joint tenants. And if married, then you get this additional third option called a tenancy by the entirety. And I'll give you the differences very quickly. A tenancy in common, on its most basic terms, means that the two buyers each buy 50% of the property. They each own half, and they can each do with their half whatever they would like. First of the two to pass away, their half will be probated and it will be distributed pursuant to the terms of that 50% owner's will. Could go to somebody other than the other owner.
Okay.
A joint tenancy provides a right of survivorship between the two owners. It's a legal fiction. It means the two owners own an undivided whole of the property, and it provides a right of survivorship, which means the first of the two owners to pass away, the property would transfer by operation of law to the survivor because they each own an undivided whole. So there's nothing for a joint tenant to leave to their heirs. Two people take as joint tenants. As long as the tenancy isn't severed while they own it, the first to die doesn't own the property, their heirs don't own the property, the survivor gets to own it on their own. A tenancy by the entirety is kind of like a joint tenancy on steroids. It's another legal fiction that means that the marriage owns the property in its most general terms. You get the right of survivorship that a joint tenancy enjoys, but a tenancy by the entirety, unlike a joint tenancy, isn't unilaterally severable, which is a fancy way of saying that both tenants by the entirety have to agree to have a lien attached to the property, to break the property up, to transfer it to another person. And this is important for judgment creditors. In a joint tenancy, if one or the other joint tenant, God forbid, gets in a car accident, has $1 million judgment entered against them, a judgment holder against a joint tenant can have the sheriff execute on the property and get that lien to break up the joint tenancy and attach to that defendant's interest in the property. Not so with a tenancy by the entirety. So long as you're married, and so long as you're tenants by the entirety, judgment debt against one or the other tenants by the entirety, generally speaking, will attach to the property. Lately, I have seen some pretty interesting, we'll call them budget estate planning techniques that some clever, well-read, but not legally trained consumers try to use with regard to the joint tenancy. I would caution your viewers to be very careful when deciding to add family members to title, especially if it's to avoid probate. A lot of times I'll see heartbreaking situations where family will see that grandma's about to pass away because she's advanced in age and she's sick, and they'll add the children to title as joint tenants. And in local jurisdictions, that can cause you some serious problems with capital gains taxes and the step up in basis. It's really beyond the scope of this discussion of tenancies, but anytime your clients are going to add, subtract, or make a decision about title, they should do it in conjunction with advice from their advisors and their accountants.
Okay, so what I'm hearing is what seems like a very benign decision of how am I going to take title has huge implications. So bottom line, my recommendation for what I'm hearing from Matt and my own experience is that don't make that decision lightly. Make sure you fully understand, and the best way to understand it is to ask a lot of questions of your settlement attorney as to what are the implications of the method of title that I'm planning on taking. Make sure you understand that and then move forward. Would you agree with that, Matt?
I do.
Okay, great. Hope that helps. Eldad Moraru, Your Personal Realtor, and thanks for being with us today.